Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in the labor law series, let us talk about disablement. What is a disablement? Temporary disablement, permanent disablement, partial and total disablements. Coming to partial disablement. Partial disablement is mentioned under section 21G of the Employees Compensation Act 1923. We have two kinds of partial disablements, one is temporary and another is permanent. Temporary is that disablement is done by testing of such disablement when there is a reduction in the earning capacity of the employer in respect to the earlier capacity. And coming to permanent disablement, if the injury caused by the accident result in the reduction of the earning capacity in respect of the employment which the employee was capable of undertaking at the time of accident is permanent partial disablement. So the loss of earning capacity or the extent of it is the question of fact. So loss is completely different. Loss is a permanent disablement and reduction is the temporary disablement. It has to be determined by taking into the account the diminution or destruction of physical capacity as disclosed by the medical evidence, and then it is to be seen to what extent such diminution or destruction would reasonably be taken to have the disabled affected employee from performing his duty which an employee of his class ordinarily performs. So it all depends upon the medical evidence, how much he is able to perform and how much he cannot perform, what is the reduction in the capacity. It is all depends upon the medical evidences. There is a case law in which Sukhai versus Hukum Chand Jute Mills Limited. Here Sukhai was employed as a cop winder in jute mill of the respondent. So on 16th December 1951, while he was at work, his left eye was injured by some flying Chinese clay balls. He was given first aid by the chief medical officer and then sent to the hospital where his eyeball was removed. Later, but he resumed his duty on 5th February 1952. He has been in the employment of the respondent company and was earning his usual wages and could do his usual work. And on 4th June 1952, he made an application for compensation for injury to his eye. So he described that the injury was a loss of vision of which his left eyeball was removed. So the court held that it can make a suspensory award. Suspensory award is something that which could be made when he can earn the same present earning capacity of an employer, but was not affected. His employment is not affected, his earning capacity is not affected, but it might likely affect in the future. This award is called suspensory award. Coming to total disablement. Total disablement is defined under section 2 clause 1 subclause 1 of the same act. When an employee is incapacitated of doing any work which he was capable of performing at the time of accident, resulting in such disablement is total disablement. So he was able to work before the accident, but after the accident he was not able to work. Then such a disablement is total disablement. Incapacity of all work is different from the incapacity of the work which an employee was doing at the time of the accident. It is further provided in the act that the permanent total disablement shall be deemed to be resulted from the every injury specified in part 1 of the schedule 1. So what are all the injuries which are specified in the part 1 and schedule 1 which have 100% loss in particular part of the body where he cannot perform his duties to the full extent, or he cannot at all perform any of his duties which he could have performed earlier. So all these are mentioned under part 1 of the schedule 1 and part 2 of the schedule 1. So it may also result from any combination of injuries in part of the schedule 1 where the aggregate percentage of the loss of the earning capacity as specified against those injuries amounts to 100% or more. So if there is a loss of both the hands, or if there is a loss of one hand and one leg, or some other kinds of examples are all there where there is 100% loss and the employee cannot perform his duties to that particular extent, and he may not be able to perform his duties in the future. That kind of disablement is called total disablement. As such, we have come to the end of the session. It's riddle time. Please answer the riddle in the comment section and please like, comment and subscribe. Thank you so much.